welcome to CondoWise Learning Series, session number 7, Construction Chaos. My name is Patricia Aaliyah. I'm from the law firm of Aaliyah Associates, and we're so happy that you could join us today. Today is part 2 of our continuing series on avoiding pitfalls, and we are very happy to have with us a group of colleagues from our law firm. And if we could advance the slide. We have Julia White with us today, Jonathan Wright, Justin Tudor, who is not part of Aaliyah Associates, but is the president of Keller Engineering. Very pleased to have you, Justin. Good to see you. And Shannon Penny, who is part of our team as well. So without further ado, we are going to jump right in because we have a lot to cover. Today's CondoWise session is actually an hour and a half because we wanted to give you time for questions, and we are covering some really heavy material today through John and Justin. So Justin, as I mentioned, and if we could advance the slide, please, is the president of Keller Engineering. We've got his bio up in the chat, and you can learn more about Justin and his work by going over to the Keller Engineering website and taking a look at what they do. Our first speaker is going to be Shannon, giving us a brief update on the pandemic. Shannon, could you please go ahead?
Thank you very much, Patricia. So hello, everyone. So as of April 8th, unfortunately, Ontario were placed back in the stay-at-home order, which requires everyone to remain at home with exceptions only for essential purposes, such as going to the grocery store, the pharmacy, or for essential work. So these measures are in effect for all of Ontario and are anticipated to be in place for at least 4 weeks. Ontario is now in phase 2 of the 3-phase vaccination plan. So it is important that you check your public health unit website for vaccine updates. So what is permitted during this time? So some of the businesses that can remain open and are of interest to the condominium industry, maintenance and repair, property management services, security services, domestic services that support the operations of households, lawn care and landscaping services, construction activities or projects, and facilities for indoor, outdoor sports and recreational fitness activities. However, that there are certain conditions that must be met for these to open. So while open houses are prohibited, properties can be shown to individuals on an appointment-only basis. It's also important to take note that short-term rental accommodations can only be provided to individuals who are in need of housing. So all guest suites should be closed at this time. Condos should continue to follow all advice, recommendations, and instructions issued by the Chief Medical Officer. So what does this mean for condominiums and the construction projects? So the questions being raised by many condos as to what is and what isn't allowed during the lockdown, especially now during the stay-at-home order. So the legislation permits certain essential services to continue. Ontario Regulation 8220 permits construction activities or projects and related services to continue. Construction activities or projects, as well as any repair and maintenance services, which are essential to the operation of a property, are permitted to continue. Therefore, we encourage condos to consider the nature of the task that is to be undertaken. While the language of the legislation at first instance seems to allow all construction activities and projects to continue, this is not the case. Not all unit renovations are essential construction services or repair and maintenance projects. While units must be repaired or maintained for emergency reasons, this is what would be deemed essential. The operations of the corporation required to fulfill its statutory obligations is what is also essential. The board has the power and obligation to determine what is essential for the corporation with respect to construction and maintenance and repair. With this said, does this mean that every project is a go? No, it doesn't. It is important to remember that all of the pandemic legislation has been implemented to limit or eliminate the spread of the virus. Therefore, this standard cannot be disregarded, but should be factored into board decisions. So a corporation could reasonably determine that an in-suite renovation would not minimize or eliminate the transmission of a virus, given that contractors would have to come into the property and travel through common elements, increasing the number of individuals attending the property, and thus increasing interactions with employees, agents, guests, and residents of the condo. It's important to remember that corporations are private residences and are required to operate in accordance with the obligations under the Condominium Act to ensure that no dangerous condition is permitted to exist on the premises. So I will now pass you over to Jonathan Wright. Thank you.
Just checking I'm off mute here. Thank you, Shannon. So my name is Jonathan Wright. I'm one of the litigation lawyers here at Alea Associates. And as part of my litigation practice, I practice in construction law and hopefully attempting to resolve construction disputes from time to time. So part of the reason why I'm here today is to talk about some changes to the Construction Act. And most notably, there was a name change from the Construction Lien Act to the Construction Act. And Caroline, if I can just ask you to jump into the next slide, please. We've got a few areas here. There's 1, 2, 3, 4, 5, 6 different areas of reform that were brought into the Construction Act in 2018 when the amendments were made. The balance of the amendments were brought into force into 2018, with some held over until 2019. They are now all in effect, so we can now avail of all of the options to help resolve disputes under the Construction Act. As part of the reform, we had some lien reform, and by lien reform, whenever we talk about construction liens, historically, there was 45 days to preserve your lien and 45 days to perfect your lien. I'm not going to go into too much detail about liens today per se. They're a very technical area. And if anyone has any questions about liens, I love talking about them and happy to answer any questions that anybody has. My bio should be in the chat. And if anyone wants to reach out, my email address is there and you're free to contact me. And similar for holdback reform, also a very technical area. The amendments brought in segmented release of holdbacks, phased release of holdbacks. Holdbacks under the Construction Act are one of the areas that if it's administered wrongly, you can attract some personal liability, in fact, a lot of personal liability for your corporation. So again, I don't want to spend too much time going into holdback reform today. Needless to say, if you have any questions, again, feel free to reach out to me and to contact me with your questions. I don't want to give you 50% of the holdback information and then for it to be implemented in sort of half measures. And then you call me later and say, we've just got sued because of some information we heard from you. So I'm not going to touch too much on it at all. Feel free to reach out. Similar for trust reform, there was some new trust accounting requirements brought into the Construction Act that now require some specific areas to address. And again, feel free to reach out with those. These are all sort of technical areas that require reform. And what you're going to hear a lot about today are 2 new areas that have been brought into to play. Adjudication under the Construction Act and prompt payment, which really go hand in hand, adjudication being the method of resolving prompt payment disputes. Again, I'm not going to talk about prompt payment. That's my friend Justin's area today, and he's going to get very angry if I touch on his area. So I'm not going to invoke the Hulk here. We're going to move on swiftly. Thank you, Caroline. Before I touch on to any of this, one of the things I always like to bring to our clients' attention is that the Construction Act, very much like the Condominium Act, requires compliance. You can't draft contracts that provide for different terms outside of the Construction Act. And where I see that happen a lot is with holdbacks. Contractors, whenever they sign contracts and engage in these type of projects, are required to hold back money for their subcontractors. Condominiums are required to hold back a percentage of the invoices that they pay to contractors. Contractors don't like having to hold, not getting paid 100% of their invoices. So sometimes they will say, well, we're not going to engage in this holdback requirement. It's okay. I don't have subcontractors. You can just pay me everything. If you agree to that contract and it requires no holdback, despite what's in the Construction Act, you're creating personal liability right from the outset. We do not want you to agree to any terms that are not outside, that are outside of the Construction Act. And that's where a well-versed, well-experienced construction lawyer or corporate lawyer can assist your condominiums with your construction contracts. The contracting out of provisions of the Construction Act are very clear, and I've got them on the screen here. If we look at section 5 sub 1, every contract or subcontract related to an improvement is deemed to be amended insofar as necessary to conform with the Act. So even if your contract has terms that try to override or supersede the Construction Act, the court's going to read in the terms of the Construction Act into your contract. Again, nobody expects you to know the terms of the Construction Act and to know when the terms of a contract are in opposition to the terms of the Act. So again, something to keep an eye out and to engage your legal counsel with. Caroline, if I could ask you just to jump on to the next slide. Only touching on prompt payment very briefly before Justin gets angry, and that's to say that prompt payment only applies to contracts entered into after October 1st, 2019. The balance of contracts that I see involving disputes are for the most part, all entered into after October 1st, 2019. But for larger scale projects or phased projects, there may be some contracts out there that were entered into before October 1st, 2019. And there are some other provisions if there's a procurement process that began prior to October 1st, 2019, and things like that. So just keep that in mind. And it's the same for adjudication. It's a contract entered into after October 1st, 2019. Caroline, if I can get the next slide, please. So the balance of my role here is to talk about adjudication. I'm going to touch on what it is, what disputes can be adjudicated, what the timelines for adjudication are, and finally how to commence an adjudication. Next slide, please. So very simply, adjudication is a process that allows the parties to a dispute to address the substance of the dispute, to make their arguments and present their evidence to an independent third party who will make a decision, and that decision can then be enforced in the Ontario Superior Court of Justice. It's important to say that adjudication isn't mandatory in that you can still enforce or to bring a dispute to the Superior Court of Justice or to arbitration or mediation. But there are certain elements of why it's important to consider adjudication that we'll talk about shortly. Caroline, next slide, please. So moving on, we have adjudication. Talking about why adjudication is necessary, if we can talk about briefly what would happen if adjudication wasn't part of the Construction Act and what happened for many years prior to the amendments. Envision a scenario where you've got a contractor who has been paid $180,000. The balance of the contract is $20,000 left, total contract for $200,000. The contractor says, I'm walking off the job. I need $60,000. You're not paying it. You're relying on the fact that the contract balance has been paid and there's not much work that's been done. But my contract says I'm entitled to payment and I can't do more work without more payment. Previously, you would have had to go to the Superior Court, commence mediation or arbitration, and to try and resolve this type of dispute. Or the contractor walks off and you go and get another contractor. All of this leads to a long time of uncertainty. You're not sure whether you're in the right. Your contractor's telling you you're wrong. You're engaging another contractor. You're spending more money. There's uncertainty with respect to timeframes for the project to be completed, uncertainty with respect to your budget, uncertainty with respect to whether the contractor is going to be successful, and a claim against the corporation for damages for your failure to pay him. So adjudication, in its essence, is an interim process that can be conducted while the project is ongoing. It can minimize the delay to the project, and that, as you'll see, you can get a decision on your dispute within about 30 to 46 days, and it's relatively inexpensive because the time frame is very truncated when compared to an arbitration or a Superior Court of Justice action. And while I said previously that adjudication isn't mandatory, once one party serves a notice of adjudication, the parties are engaged in that process. The contractor, if the condo serves a notice, can't turn around and say, I'm not engaging in this adjudication process. They have to do so. So Caroline, if I can have the next slide, please. So let's look at what can be adjudicated. When you have a dispute that involves any of the following that are described under sections 13.5 sub 1 of the Construction Act, you can bring about this process. Specifically, the value of services and materials provided under the contract, the payment under the contract or change orders, disputes with respect to notice of non-payment that Justin's going to talk about, set-off claims that you may have where you're saying, well, we're not paying this because you have caused damage to the condo, and we have a claim for 40 grand against you, you're claiming 40 grand from us, we're not going to pay anything, everyone should walk away. And then holdback payments or non-holdback payments, or refusal to pay holdback payments. And then there's a caveat that if any of the parties agree and you're on good terms and you say, we're a bit of an impasse here, let's just engage in the adjudication process, we'll get a quick decision on this and we can move on. The parties can agree to submit those matters to adjudication. As I mentioned, the timelines for adjudication are very tight. And when you look at or compare them to the timelines in a superior court action, superior court actions last for months, if not years. They're expensive. There's a lot of uncertainty because of the time frame that you're engaged in the process. There's a lot of steps. You're relying on the time frames of your lawyers to be available, the judge, the scheduling of the other lawyer, the availability of parties to be examined. So there's a lot of consideration that goes into this. When we start an adjudication, the claimant starts it by serving a notice of adjudication on ODAC, which is the authority appointed under the legislation, and the responding party, if we consider the claimant to be the condo and the responding party to be the contractor. Once notice of adjudication has been served, the parties have 4 days to choose an adjudicator. If they can't choose an adjudicator, and there's a register on the ODAC website, ODAC can appoint an adjudicator for them. Again, reducing the amount of time that there is delay on the project. The adjudicator's fee is negotiated between the parties, and if that can't be negotiated, well, ODAC has a set fee schedule that can be referenced and agreed upon. There's also a process that can be agreed upon. There are 4 pre-designated processes that the parties can agree on, ranging from very brief written submissions to, at the longer side of things, written submissions and oral submissions to the adjudicator. Very important that once you have appointed the adjudicator, the claimant, or the condo in this case, has 5 days to submit its supporting documents to the adjudicator. Again, it's a much tighter timeline than an arbitration or a superior court action. And from a lawyer's perspective, please don't call your lawyer on day 4 asking them to assist with an adjudication. The supporting documents are going to be really the only thing in the balance of cases that an adjudicator looks at. And it has to be done properly. The documents have to be concise and they have to be relevant. And then after the adjudicator has received the claimant supporting documents, it will set a deadline for the respondent documents to be provided and served. And then the adjudicator will make a determination within 30 days after the claimant makes its submissions. So you have a very tight timeline. The adjudicator can extend, if necessary, the timeline by up to 14 days, and then can extend that beyond the 14 days if the parties agree to it. But this is all aimed at keeping the project moving, keeping it on track, and to minimize the delay for the parties. When you're drafting a notice of adjudication, it's going to be the first document that the adjudicator, or the first substantive document that an adjudicator looks at. It needs to be well written, concise, and detail all the points that the adjudicator needs to see. There are certain prescribed things that must be in the notice of adjudication for it to be a proper notice. It must include the names of the parties, the nature and description of the dispute, including the details of how it arose and when it arose, the relief requested, and include the name of the proposed adjudicator to conduct the adjudication. When we're in the adjudication process and an adjudicator has been appointed, Carolyn, if I can get the next slide, please. We have certain things that the adjudicator can do. The adjudicator can issue directives on how the procedure is going to be conducted. If he needs time, needs more information, the adjudicator can ask for that. The adjudicator can ascertain the relevant facts in the law and make findings with respect to both. The adjudicator can visit the site. He can determine that he needs to go out, he or she, sorry, can go out and view the site and get a better appreciation for what's going on. Can also retain the assistance of an expert. So if you have a practicing lawyer, a retired lawyer that's adjudicating the dispute, but they feel that they need the assistance of an engineer, they can go and obtain the assistance of one. And then really they can conduct the adjudication in any manner that they see fit. So it's a bit of a catch-all there, but the adjudicators are tasked with determining the process and to adjudicate the matter. So really it's in their hands. And just to summarize everything, I know Justin's got a lot to say. Adjudication can be conducted, as I said, in a number of ways, and there's pre-defined process for that. And it can be in writing, or it can include oral submissions. And the adjudicator then will provide a decision or determination within 30 days after receiving the documents of the party who commenced the process. Talked about how it can be extended by 14 days, or if there's a specified period in the contract that can deal with that. There are written decisions. So once the adjudication has been completed, there will be written decisions provided to the parties, which then can be admitted into Superior Court if they need to be provided as evidence. And that determination is imminently binding or immediately binding upon the parties. There can't be any dispute as to whether or not the adjudicator said that something has to happen or a payment has to be made. And then the party saying, well, you know, the adjudicator's really just, you know, it's more of a guideline than anything. Similar in the manner that I tell my wife that speed limits are just guidelines. It's binding immediately. And then after a decision's been made or a determination's been made, the party that has to pay funds, if that's the nature of the dispute, has 10 days in which to pay. And if the amount payable to the contractor, for example, is not paid, then the work can be suspended, termination can happen, and the parties can move on. So subject to any questions, that's what I have to say on adjudication. I'm happy to answer any questions now or at the end after Justin's finished.
I think Jonathan, Julia had a couple of questions for you. Julia, do you want to go ahead?
Yeah, I just have two quick questions. My first question is just, can you explain how the adjudication regime under the Construction Act intersects with the dispute resolution and ADR terms under CCDC?
So the CCDC, I'm just going to refer to the CCDC2. It's the one that I work most with. I believe it's under General Clause 8, contains a dispute resolution procedure that includes both reference to a consultant, a mediator, and an arbitrator. And Section 11 of the Construction Act provides that a party may refer the matter to adjudication under the Construction Act, even if the matter is subject of a court action or of an arbitration under the or the Arbitration Act. So, with the caveat is, as long as that action or arbitration has not finally been determined. So if you've got an arbitration and it's been determined, you can't bring it back to the adjudicator, but you can intersect with these things. You can have the provisions in your CCDC contract that say the dispute resolution requires you to go to a consultant, mediator, and arbitrator, and you can try and have that preliminary determination done by the adjudicator under the Construction Act. So having those provisions in your contract, at least in my opinion, is not conflicting, and you can engage. You can actually engage in the adjudication procedure if you have an arbitration that's ongoing currently that's not been finally determined.
Cool, thanks. Second question, can an adjudicator change the terms of the contract, including the holdback amount?
Holdback amount, no, it's a statutory requirement. The adjudicator can determine how much of a holdback is owing if there's a dispute with respect to that, or not owing, as the case may be. In terms of changing the contract, in my opinion, no, they're related. The arbitrator or the adjudicator's jurisdiction is only related to the things that are described in the Act. So things like payment or non-payment, change orders, and things like that. To the extent that a contract requires payment to be made at certain times, the adjudicator could, I believe, come in and say, well, you know, there's a progress draw here, and I don't find that the progress is sufficient for that payment to be made. But for the material terms of a contract, in my opinion, no.
Thanks.
And one final point, that the adjudication regime can only be used while the project is ongoing. If you have completed the project and you discover an issue after the fact, the adjudication, although you may serve a notice of adjudication, isn't mandatory anymore. So it must be used while the project is ongoing. Thank you.
Okay, thank you. So now we're going to move on to prompt payment compliance. And Justin, I'm going to let you take it away and take us through this. I think Justin is still muted, so there we go.
I think I'm unmuted now. Great.
There you go. It's easier to hear you.
Yeah, thanks for inviting me to talk about something I literally love talking about, prompt payment of construction contracts within condominiums specifically. And I want to appreciate Jonathan for walking us through the adjudication regime. as was mentioned, effectively the law has changed to require people and owners to pay their bills more promptly and more clearly to contractors. The adjudication regime was put in there to give that legislation some teeth. So if people weren't following it, there could be a quick turnaround and quick decisions to keep the money flowing. What I'm going to walk through today is effectively the changes to the payment legislation, how those changes specifically affect condominium, and some solutions that you should be looking for from your consulting professionals or management professionals with respect to how they need to behave under the New World Order to make sure everybody is well covered. Perfect. So, sorry, just 1 second. So as Jonathan mentioned, the biggest change are the change of the name, that the statutory holdback periods changed from 45 to 60 days, and the introduction of the prompt payment and adjudication regime. And I'm going to talk at length about what the prompt payment means. We're going to be coming back to this a little bit, but we have to always envision what a typical construction chain is. It's not just the owner and the general contractor. There's a consultant over on the side here. There's a general contractor. He might have a window subcontractor or a masonry subcontractor, and they might have suppliers and sheet metal trades. The idea is that money flows through each one of these phases, often at 30-day increments. So if there's a snag at the owner's side, adding 15 days onto it, that can trickle down in a big way. And the legislation was meant to address those trickle downs and tighten them up. So when we look at the CCDC2, the standard construction contract, I've laid out a little bit of a graph here showing how invoices are typically processed in the old world. So the contractor, Mr. C here, would send an invoice to the engineer or the consultant, and the engineer or the consultant would evaluate that. And often, the evaluation would just send it back to the contractor and say, you're out of your mind. You haven't actually installed 4 balconies. You haven't even moved to site. Send back a real invoice. Or the evaluation would say, yep, this is fair and reasonable, and the engineer would issue a certificate of payment. All that would happen ideally in under 10 days. The CCDC then requires that the owner pay the bill within 20 days of that certificate of payment. So in a perfect world, that makes sense. Everything flows. The invoice that's reasonable gets paid within 10 to 20 to 30 days. But we know even in the best situation, that's not how the world works. In condominiums, this is the common process of CCDCs. The contractor will send the invoice to the engineer, same as the original way. The engineer will evaluate that, send it back for negotiation, or issue a certificate of payment. That's no longer going directly to the owner. It's typically going to the property manager. The property manager will then send it over to the board, but that board might not evaluate it, might not even see it till the next board meeting. They might also do an extra contractual review here. So a review of the engineer's certificate of payment. The engineer or the consultant in a standard CCDC is the authority on whether that certificate of payment has been issued. But this extra evaluation sometimes comes with questions, sometimes comes with, well, should we really be paying this much? Or when are they going to be doing another part of the work? And this can slow down processes too. And then after everything, they'll put in, the payment will be issued. Instead of this taking 20 days, this often can take 60, 90. It can get very, very extended depending on the frequency of board meetings or the how often checks are created. Or this non-contractual review. All of these things, even when everything is fine, can complicate things and extend the period of payment. So what does the new Construction Act impose? The new Construction Act, the prompt payment terms effectively say that now the contractor must submit a proper invoice, and I'll come back to those words, to the owner. That owner must then evaluate that invoice within 14 days, no longer the 10 in the CCDC. And if there's no issues with it, payment has to be made within 28 days. And as Jonathan suggested, if that payment isn't made, there is a notice then to commit to go to the adjudication and alternative dispute resolution if that payment isn't made. Let's say though, the owners receive the proper invoice and disputes it and disagrees with the value. Within those 14 days, they have to issue a notice of non-payment or a notice of partial payment back to the contractor that says, formally, we disagree with this value. We're either going to pay you part of it or we're not paying it at all. And if those notices are properly filed within 14 days, then the resolution can happen generally within the contract. However, the contractor still has the right and sometimes the obligation to file a notice of this non-payment if the payments aren't made in accordance with the 28-day requirement. It gets a little hairy on these notice of partial payments. What if you get an invoice from a contractor that is mostly reasonable, but has an extra $15,000 on it that you don't think is fair? And the contractor will not remove that from the invoice. You have to pay what you think is reasonable, dispute the part that you don't, and even if the contractor disagrees, you can end up in this adjudication regime. I went to a mock adjudication regime when put on by two solicitors from England who were showing the Ottawa Construction Association what this looked like, and it looked like lawyers just yelling at each other for weeks on end. The ADR looked like a bit of a mess, that's for sure. So this notice isn't simply writing back to the contractor and saying, look, your invoice is wrong, I'm giving up on it. No, there's an official form that has to be filled out from the Ontario Forms website that says the full amount of the invoice, what we're disputing it, and why we're disputing it. And this all has to be filed within 14 days. A proper invoice has a lot of components. A proper invoice now is laid out in the terms of the agreement. It says that it has 7 parameters, but largely it has to be clear who is sending it, who it's to, what the work is for. It has to reference a project or a PO. It has to reference the terms of the account and when payments are due. And it has to be very clear about what's included. The other provision that's allowed for in a proper invoice, and this is a little gift they gave to owners, is that provided it's very clear up front, a proper invoice can also contain any reasonable expectation addition for the contract. So a proper invoice could, in theory, include a schedule update. So how many times have you been on a project where the contractor simply won't provide a schedule? It's reasonable that now a contracting professional could put a schedule update as a requirement of a proper invoice. And the invoice, if is received without a schedule, will not be considered proper, and that 14-day clock wouldn't start. The biggest issue with all this is that this legislation doesn't allow for any consultant review. Now, I'm not saying consultants are the be all end all, the everything required. You can do projects without consultants. However, this legislation does not care if your consultant hasn't read the invoice. It doesn't care if the consultant's issued a certificate of payment or not. There's no space in the legislation for the consultant. The biggest issue too is why this can't be ignored. Everybody thinks that we're going to have no issue with our contractor. They're very reasonable contractors. We've always had a good relationship. If we pay them 45 days, that's fine. But you have to remember, this legislation works at every level. So the general contractor is effectively a contractor, owner, to the subcontractor. And if he doesn't pay his subcontractor or provide that notice within 14 days, the subcontractor has the same rights to send the general contractor to adjudication as the general contractor does to the owner. So this means there's completely a scenario where the general contractor doesn't get paid till 45 days and is okay with that with the owner. But his subtrade says, I sent you a $100,000 bill a month ago. You haven't paid me. You haven't provided notice. I'm sending you to adjudication and you're gonna pay me. I've taken the adjudicator's training. There isn't a lot of room for nuance if it comes to missing the notices or not paying. If the notices weren't provided and the payments didn't happen, then that adjudicator rather quickly is gonna say, without nuance, pay the bill. It's interim. It can be set off. But if you think a general contractor is going to pay a bill $100,000 to a subcontractor out of his pocket and ever make that mistake again, it's not going to happen. General contractors are going to protect themselves and ensure compliance even with their very good clients and owners.
Justin, can I ask you a question then?
Absolutely.
If the subcontractor takes the general contractor to adjudication, does the owner have to get notice of it or participate in that, or could it just be between those two parties?
My understanding is it can just be between those two parties, specifically if, so there's a requirement too. Let's say the general contractor doesn't get paid after 28 days. His onus, if he didn't receive a notice and didn't receive payment, he is to send a notice to the owner that he intends to send them to adjudication within 7 days. This is explored a lot more in the flyer on our website, on our resources page, where I really lay out the timelines for these notices. But if let's say even as an example, the owner did provide notice of non-payment and the general contractor didn't notify the subcontractor of that notice of non-payment, the subcontractor is going to get that money directly from the general contractor if it goes to adjudication.
Oh, okay.
So you can see obviously why this might be problematic for condominiums as they go forward in terms of the relationships they have and the timelines on some of their deliveries. The biggest problems with integrating the existing legislation is I have 4 that are pretty worth delving into. There's no space for consultant review. So you're going to have to make space because it's not going away anywhere. Where you've signed a CCDC contract, you're going to rely on your consultants and you're going to have to find space to make it work. The other aspect is 14 days for evaluation with the boards are doing extra contractual evaluations and 28 days to make sure the check gets signed from the board. In the days after COVID, now that we're all used to remote working, this might work a little bit better, but these are generally reasonable timelines in the general working area, but they're a little tight for most condominiums when you look at their process.
Justin,
sorry, go ahead.
Just a quick question though, in terms of making room for the consultant, the CCDC2 generally has a very big role for the consultant to play. Why do you think they were ignored as part of this process?
I have to envision, it's a great question. I have to envision that this legislation, this wasn't created, the CCDC2 is a consensus document. Bunch of contractors, bunch of engineers, bunch of owners get together every 3-4 years and they say, what do we need to change here? Do we need to touch it? And everybody agrees to put risk where it is. This legislation is really contractor driven. It's to refocus and keep the money going. And I almost think that owners in general deserve it. For years, they've been skirting the issues of how long they're going to pay. Nobody pays within 30 days. And this is a reactionary response to that. So the idea that why the engineer wasn't considered was there are ways to modify your CCDC contracts to make this work. They just didn't want, they wanted to rule out the option for an owner to say, oh, well, my third-party reviewer hasn't paid it, so I can't pay you lately. They wanted to put this onus on owners and consultants to really get their stuff in gear here, to implement plans to make sure we meet these timelines.
I think, Justin, if I can add one thing as well, I think the process that you're describing also would negate the need for a lot of construction liens tying up units and common elements as well if notices of non-payment are sent out on time and things like that. So reducing costs everywhere. Also,
there's ways to see the new legislation as beneficial in that way. No longer will you have these liens in the middle of projects or right at the end, because a decision can be made, the money can flow. It doesn't mean you're paying for something that you're not going to pay for in the future. It just means the cash is moving and there's not this permanent fight about whether this was owed or not on the cash flow side. So in addition to the insufficient time to actually get the checks out, in my opinion, there's no legislative allowance for multiple reviewers. So it says the owner reviews the invoice, the owner advises whether their notice should be issued. In fact, the legislation specifically excludes it. So I have an excerpt from the legislation. A provision in contract that makes giving of a proper invoice conditional on the prior certification of payment certifier on the owners of prior approval is of no force and effect. So there is no provision that you can make a proper invoice contingent on the consultant reviewing it. They've written it out of there entirely. They say if you want to dispute it, you have to play the notice game that they've created on Ontario forms. So there's no provision in the legislation for an owner and an engineer to review it. Furthermore, these deadlines are real. The 14-day notice from when the proper invoice is received is a clock that ticks whether you notice it's received or not. All of the deadlines in here, they're the 14-day notice deadline, the 28-day payment deadline, the contractor's 7-day notice up and down the chain deadline, the payment within those 7-day deadlines. All of these are rather rigid. The 2020 report on prompt payment for Ontario in the greatest year of COVID said that only 32 adjudication requests were made, and furthermore, only 3 rendered in a decision. So there's not a lot of, for lack of a better term, experience or cases to judge from here about how this is going to be used. But we do know 32 people toyed with the system and learned something from it, and 29 of them decided to stop before they got a decision. So it might be used as a flex tool. It might be used as just a warning, but it's going to be interesting to see how this grows because people are going to use it, that's for sure. So I have a few more minutes here. I want to go into what I think are the 10 solutions to the 4 problems that are in there. And this is on the property management side. This is on the consulting side. This is what I think best practices might look like to really resolve these issues in the future. 1, you have to modify your contract to require dual invoicing. So this is to say, now the supplementary conditions, the CCDC says, send your invoice to the consultant reviews. Now the contract really needs to say, send it to both. Because it has to go to the owner, it has to go to the engineer. We want that proper invoice to trigger, to be in line with the legislation. The second thing is we want to make sure that consultants' roles fit in tandem with the legislation. So while the CCDC allowed 10 days for the consultant to review it, and conceivably the consultant could still provide you a review on day 10, the owner could disagree with it, say there's no money in the bank, and issue a notice of non-payment and still be compliant. It doesn't seem likely, especially in the world of condominium. So those engineers have to tighten up that evaluation time within the CCDC. So it's very important that when you're engaging with your consultants, that you talk with them and your agreement with them advises how promptly they will dismiss or provide certificate of payments on their on the invoices submitted.
So Justin, let me ask you a question then. Is there a way in the process of managing an actual project in the construction, the construction meetings, the construction timeline, to sort of preempt this with the client? Because, another part of this is when you say give notice to the owner, you're usually saying give notice of the amount to property management. Property management then has to get it to the owner as well. So is there a better structure along the way that even if we're seeing a problem, let's say with the contractor, that we could bring it up in advance of even being issued these invoices?
Absolutely. And that actually leads to my very third solution here. Draft invoice review. This is not uncommon. It's not novel, but it's more important than ever now that the engineer and the contractor in a CCDC2 relationship have very clear expectations that a draft invoice will be submitted to the engineer and the engineer only. And they will get through all their fights about those percentages of the balconies done before a proper invoice is submitted to the owner. This is where your relationships with your contractors and your consultants will really play effect. That if all the evaluation is already done and the consultant feels really reasonably secure that the invoice that's submitted is fair and reasonable, that evaluation can happen in 1-2 days because the work has already happened once the proper invoice gets submitted. It doesn't require a contractor to do that. It doesn't mean a contractor who's trying to get over you won't submit it directly to the owner and not CC the engineer. But building those relationships and making sure the draft invoice is in there preempts that in a big, big way. The fourth is really the notification process. So what we're doing and what we're encouraging everybody to do is to keep everybody aware of the process. So if an engineer or an owner receives a notice or an invoice, everybody should be made aware, even if the evaluation is ongoing. Owner, we've received this invoice. We're evaluating now, rather than owner, we've received this invoice 10 days ago. Here is your certificate of payment. Pay the bill. We're letting people know how this process goes so that, to answer your question, Patricia, if there is issues on the job, everybody knows the clock is ticking. So there might have to be considerations for where board members are. There might have to be considerations for if anybody's on vacation, that this clock is ticking every month.
Yeah, and I think that the key thing though is how do you keep the board apprised of that? Do you have somebody that's part of the board attend at the construction meetings, or do you have a separate time for managers to talk with the board to let them know what's coming? Because I'm sure there are going to be benchmarks, especially we're seeing a lot of balcony refurbishment projects underway right now, and you know, people know that the project's going on, but it's how do you keep tabs on what the expectations are moving through the project, and when is it time to, you know, have these conversations before we get into a time crunch?
Well, depending on the type of project outside of this, it's very common to have regular construction meetings. I find that especially when you're in people's units, like on a balcony, if you're not sitting down with the key stakeholders at least once a month to have a conversation about the things that are dragging, or the things or the invoices that are coming up, it's really in there. The educational component comes, we're showing, I'm going to show a few ideas here, but we're trying to hit people over the head every chance we have. A payment certification that goes out, a letter of award that goes out. Our proposals now are talking about owner responsibilities in terms of the new legislation, just in the hopes that if somebody reads it, you can understand that things have changed a little bit.
So let me give you another problem that I see, and interpret it in the parameters of this, where we have a really big project, let's say window replacement over a very big multi-story building. And what's happening is that, you know, they're going ahead, they're doing windows, and we're into installation, but there are problems with some of the prior installations. So, you know, trying to be efficient in terms of not expending a lot of money or wasting a consultant's time, you know, you have periodic weekly reviews, let's say of the 15 suites that have been done. You aggregate the deficiencies as noted by the consultant, but there's this cycle, right? There's a cycle of they want to keep going and installing because you've got new windows arriving, but then we've got this issue that the work isn't satisfactory. So how does that play into this when they also want to issue, you know, their invoice?
So actually it fits in fine in that they are separate. So your consultant is allowed under the CCDC to set off money associated with deficiencies. In fact, they're required to. And that set off comes off of a future invoice. So the work that was done under invoice 2 is deficient. And it's not discovered until invoice 4. Invoice 4 will have either in the negotiation or in the notice of non-payment proportion saying, we're taking this money off of this invoice because of the deficiencies discovered with an option 2, provided you provide notice within reasonable time and say why. You are in your best case scenario, you have to do that. But that's the type of thing that the ADR is going to be looking to check on. Now, the ADR can go into whether that was an appropriate, the adjudication can go into whether that was an appropriate set off. They can do those decisions. But if you don't provide the notice and provide the reason, it's a slam dunk the other way. There won't be any issues.
But what
But
about,
largely though,
okay, go ahead.
largely though,
Yeah.
in the interest of moving it forward, that can likely be negotiated out on progress billing form. Say,
Okay.
we're going to show this money down.
All right. But your point is well taken, trying to move it forward, right? Because let's say we're trying to get to the end of the project, but we have this list of deficiencies. We don't want the contractor to leave with the majority of its team and go on to the next project. And then we're waiting months and months for, somebody to come back and rectify work. And I've seen this happen on landscaping projects where they do, a major part of the installation, but then they have another project and they move half the team. So how do we, help ourselves here? Like, is it more just contractually our expectation, or is it really through the monetary set-offs being, very clearly, we're not paying you until you're done?
Hold the money. I really am that person. You need, especially at the end of the job, the defects that exist, have the value of the money held back to have somebody else complete it, not to have the contractor complete it. You need to have the money held back to have somebody else do it. And you know what? You take that off and they come back and do it. It's constant as gravity. And that's where the biggest mistakes happen. That's probably when they talk to you guys the most, when the money isn't there, because if the money's there, the contractor comes back for it. It's separate from prompt payment, but it's just as critical and important.
Okay, thank you.
So going on here, because Caroline's about to yell at me for time, the key thing too that we're trying to put in is rigorous proper invoice review. So if there's a parameter of the proper invoice that's missing, that clock doesn't start. And there's no obligation to tell them that the clock didn't start. But if you say, look, we didn't pay because we didn't get a proper invoice, that's a reasonable defense without even, or a reasonable term in terms of the adjudication without providing notice. You have to receive the proper invoice for that check to start, clock to start. We've talked about it in the office to just put a requirement in for a proper invoice, to put a red sheet of paper in there. Just the idea that if there's not a red sheet of paper, we know we don't have to look at it. It's kind of like there's a old story about a band putting 99 brown M&Ms in a bag to make sure that they were following the rules of the contract. And we thought that red sheet of paper was a good idea. The other key thing is we're reminding owners that if you get an invoice that isn't CC'd to your consultant, that clock has started if it's proper. So anytime an owner is getting an invoice, property manager, they have to send it to their engineer, whether or not they're sure they're CC'd or not. The other thing we're doing is building in client timeline reminders. So the engineer is going to issue a certificate of payment. That certificate of payment is going to clarify a few things. We received a proper invoice on this date. That means you need to pay the contractor by this date. If there's issues with the notice, we're going to tell people you need to provide the notice by this date. All those things need to be reminded in there. So by that time, the other just putting in not just the deadlines of payment, but the deadlines of the notice, where you can get the form if you need to do it. The other thing that we're trying to figure out and what we need to resolve is if you're in this spot where there is a dispute that's happening, and whether or not it's right or wrong, there's going to need to be some support from the consultancy side in terms of where to go, and that's what we're making sure that we're building in to your consultant should be thinking about going forward. And the last big thing that we're putting in to make sure condominiums have enough information going forward is this type of education. We're briefing condominium owners, we're briefing contractors, we're briefing partners in the industry in this type of setup, just because we want to make sure everybody understands the magnitude and importance of adherence to this issue. There's a few things that I want to they're just general thoughts I've had over the last year, and we touched on a few of them. Prompt payment was really designed for the contractors and subs. I don't know how condominium owners will navigate the ADR process. It may look like lawyers yelling at each other. I don't know whether the smaller management companies will change their signing practice. If you're only cutting checks twice a month, this will not work for you. Your major construction projects will not comply with this. I don't know what will happen when boards don't meet for several months and nobody's there to approve a payment. I'm wondering who the first party to mess up is going to be and what that impact will be. I think it'll be the GC. I think it will be the GC not getting paid and not telling his sub that he didn't get paid, and then the sub is going to ding him for fees. As Jonathan said, all projects require adherence, not just where there's a consultant. It's a construction project under the Act. It needs to be adhered. As good as the relationship is, the contractor will be providing notices because this can't be ignored by them. We want everybody to be educated, be aware, and ensure that the people you're relying on are aware and ahead of this as well. That's all I got, but there's a really good Q&A slide here.
Well, thanks so much, Justin. That it was, you and John have taken us through a lot of information, and I'm not sure if I'm excited about this new format and legislation, but obviously we have to deal with it and make two things work, like a CCDC and the expectations under that and how we think the relationship should be, and then these Construction Act requirements. In terms of, your points of how to, I guess, deal with, even something like boards that don't meet for several months, or even shared facilities committees that don't meet for several months because we're seeing that as well, construction being undertaken by shared. Any thoughts in this virtual age of what we could be doing and what you're seeing your clients do?
Yeah, there's no great solutions just yet. I think most of them are going to come from trial and error. But what we've laid out there, if you're meeting regularly regarding a project, if early on in the project, everybody understands that you won't be able to, deal with this invoice at the next board meeting. You need to deal with the invoices when they come. And if provided that mentality is there, you don't need to necessarily figure out exactly how you deal with the invoices, because there should be enough time to do what you need to do within there. You can't ignore payment anymore, which is kind of what everybody did and how we ended up in this relationship. It was built for big projects. This is built for new construction, $20 million ones, but it applies down to the $10,000 fence replacement, fence repair. It's good for the goose and awful for the gander, I suppose.
It sounds like it will be. John, what are your thoughts on ADR in terms of the ADR process? Is it going to be you yelling at another lawyer all the time?
As much as I'd like that, it seems that it's going to be mostly done in writing. There are 3 pre-designed processes that the parties can engage in, and it's only the 4th pre-designated process that allows for oral submissions. So to the extent that a lot of it's done in writing, I fully expect that that's how things will go. For the more expensive projects or where there's a lot more money in dispute and there's more at stake, I can imagine there'll be oral submissions in a lot of those cases. I like to think that Canadian lawyers are more polite and engage in much more collegial discussions in the courtroom. That's not to say anything about, Shannon's people being from the UK, that they're any different, but, to the extent that it's all in writing, we can shout at each other in writing. It's okay.
Well, and I think that the other thing is too, what we're looking for is always in disputes to try and narrow the issues, like try to get the best evidence for our clients. And I'm wondering, if it's less about persuasion and if it's more about technical information and having it presented in a timely way. And, I had one question as well as about the rules of evidence. Does anything go here? How does that work? I know we can hire an expert, but who is an expert and how does that work?
That's a good question. In terms of the rules of evidence, I think I think anything will likely be considered as long as it's relevant by the adjudicator. You don't have legally trained people doing or prescribed as being the only adjudicators. And Justin, you've taken the training, so feel free to weigh in. But you know, somebody like Justin, if not Justin himself, is able to adjudicate these disputes. So to the extent that you have expert reports and another person or the responding party doesn't, well, you know, the adjudicator's only going to have one set of evidence to what to use to make a decision, or one set of heavily weighted evidence to make a decision on. So I think it's all relevant, and certainly to the extent that I was involved, it would be if expert evidence was needed, we could go and get it. Although you've got a very short time frame from when you bring on or appoint the adjudicator to have all your written documents submitted. So you know, there's going to have to be background work done before the adjudicator is appointed to allow you to have a full response or full submission to the adjudicator for their consideration. But Justin, have you any insight you can give us from the training that you took?
Yeah, so effectively, what I got the feel of, it's really the adjudicator's job to make a decision, not necessarily to investigate every inch of it and make sure it's the right decision. It's to make the decision based off the evidence is out there. And if there's only one side of evidence, then they don't necessarily need to get to the bottom of the problem. These are interim decisions too that can always be set off. They're not that this their job really is to make a decision. We expect most of them to be about notice issues, so the decisions will be very quick and prompt. But I agree, it can go to the lawyer level, it can go to extra evidence, but it really got the feeling that we were looking at the first model a lot. Make quick decisions based off what's in front of you.
And that was really the driver here, right? Is just to, you've got to get people moving and keep the project going, right? So I wanted to know if we have any questions from our audience. Yes, we can get the slideshow to share with your board. We'd be happy to do that. And we will have the video available on the website as well. We will also provide links directly to Justin's website because they have more information there as well. A brochure that would be helpful in overviewing this process and looking where you can tweak your process as well with your legal counsel and your consultant. Any other points or thoughts that you'd like to share with us before we wrap up today?
Nothing from me.
All right. Well, thank you so much, Justin, for making the time. I appreciate you condensing all that information into such a short time frame. John, as well, thanks for the oversight into the ADR process and how arbitration is going to work. Thank you to everybody for being with us. And like I said, the video will be up and available. And we'll be looking forward to our next CondoWise session. We'll be sending more details. What I did want to tell you about, though, is that there are a lot of CCI events coming up, and we have a full listing of them. You can go to our website to find them. We have some very exciting courses here in Ontario for those of you who are Ontario-based, but we also have courses across the country offered by various CCI chapters that are continuing on in great director education formats and content. So thank you again to everybody. Have a great afternoon, stay well and stay safe, and we will continue to keep you updated. Thanks.